Let's pick up now on the recusal this morning of Judge Piet Koen from former President Jacob Zuma's corruption trial. Koen recused himself, saying it's in the interest of justice that he withdraws from the matter. Zuma's team called for him to step down, saying Koen had expressed a view in favour of State Prosecutor Billy Downer. Judge Koen will now take over the case. Koen said today his continued involvement could create the impression that he's biased against Zuma. Well, I'm joined now by legal analyst Elton Hart. Elton, thank you very much for joining us. Before we jump into the Zuma case, I do have to ask from a legal perspective, bearing in mind that we've just heard the President saying that the governing party is in broad agreement that we need to declare a state of disaster over load shedding. Our experiences of a state of disaster, most recently, of course, is COVID-19. From a legal perspective, do you think that this is something that could assist in us moving away from load shedding? Do you think that it is a complicated arrangement to embark upon?
Sally, first and foremost, obviously one needs to look at when a state of disaster is called, then it means that the ordinary processes of electricity supply and procurement will be affected, which means that the government can then on an ad hoc basis decide how electricity will be provided and what we as consumers will pay for this electricity. And it's no longer that consultative process. So it might have a negative effect on us, and we might pay much more for electricity for having less electricity. And as much as the President said there and said that this is, and I see also that the Black Business Forum agrees with the President, but one needs to carefully unpack this before we just throw it around, because it may help us, but what if we don't get the right capabilities and capacities to actually fix our current load? Then we will be in a worse state than we were, and we can't really use the Constitution now to protect this right that we have. So in a nutshell, I think it's much more complicated than what meets the eye, and one should not just jump because it's now a quick alternative that one needs to see. Did it work in other countries? We need to see it as a frame of reference that we can draw from before we can move into a state of disaster, because we know a state of disaster has disastrous effects for the country, for the economy, and how we function on a daily basis.
Thank you so much for that comment. Let's now move on to what we booked you to chat about. This is the fact that Judge Piet Koen has recused himself. Often we hear of judges being asked to recuse themselves, but most of the time they don't. So talk me through what the process is when a judge is asked to recuse themselves.
Obviously, a judge can on its own decide to recuse himself if he feels that he's too personally connected, or he is maybe connected to one of the people involved in the case, be it a party or an accused person. He should recuse himself, and he can do that by himself. But also it can happen when one of the other party or one of the parties involved in the matter feels that there is a reasonable apprehension. There should not be actual bias, just a reasonable apprehension that there is bias. Then he or she can actually bring that application to actually get the judge recused from a case. And we could see Judge
Elton. Elton, I'm just going to check if you're still with us. It looks like your picture has frozen. Just let's try one last time. Elton, can you hear me? All right, we seem to have lost our connection with Elton. Let's hope we can get him back to finish that conversation. In fact, I'm being told he is back. Elton, I believe you're back with us. You had a moment frozen in time for a second. You were just explaining to us about how anyone really can recuse themselves or be asked to recuse. Do you believe that Judge Koen made the right decision for the right reasons?
Sally, I think to protect the integrity of the judicial system and the process, I think Judge Koen has made the right decision, because he already made a decision that he felt that former President Zuma does not have a special plea with merit, which is that Advocate Billy Downer lacks title to prosecute. And further, he also expressed strong views pertaining to the confidentiality of the sick note or the medical records of the president that was used in the application when he was ill, so that he be afforded an opportunity and adjournment. So I think that on its own if the trial would commence, those things will become an issue again, and his defense team then would raise it again, and then that creates that reasonable apprehension to say that, listen, you already made a decision that our special plea is not good enough. You already had strong sentiments about the confidentiality of my medical records. So that perceived bias is somewhere lurking there in the background, although you might not openly say it or display it, it is there, and I then won't get a fair trial as envisaged in Section 34 of the Constitution, and hence I'm requesting you to remove yourself. And I think Judge Koen did very well for the process to make sure that no further applications of interlocutory nature is brought to actually delay the equal commencement of the trial.
So I suppose in this case the judge has to judge themselves. So that's quite a tricky process, but I guess that's what they're trained to do. So yeah, the case is now going to continue under Judge Koen mid-April sometime. So this process of the judge recusing himself, does that mean that actually no time will be lost over his decision today, or are there likely to be more hiccups? Because we were hearing earlier from our reporter that there might be other applications brought before mid-April.
No, there's obviously you have a right to bring an application, but I don't foresee any application that the former president can bring at this stage. He has brought all his applications. He has gone to the SCA with the application that was for the stay of prosecution. He was refused leave, so he cannot go any further with that matter. The Constitutional Court also shot it down, and then obviously a court cannot dictate to the NPA who a prosecutor on a case should be. Although I'm of the view that the NPA should just replace Advocate Balidowner with somebody that is just as competent as him, and then the trial can proceed, and all these interlocutory applications would then fall off the table. But the NPA has a choice as to who they want on the case, and currently they feel that Advocate Balidowner is the best candidate to actually make sure that the case is prosecuted to the T because of his in-depth knowledge of the case. So that is my now, but I don't foresee any other application that can be brought that the former president has not already raised and brought before court, and a decision was made pertaining to that.
All right, so it should be all systems go come mid-April. We'll have to wait and see. Thank you so much, legal analyst Elton Hart there.